Welcome back to Left Coast News. Buckle up. We're ripping into House Bill 1152, the Democrats' latest attempt to lock down your rights in Washington state. This bill, framed as public safety, would force gun owners to keep firearms locked up in their homes and vehicles at all times unless a narrow list of exceptions apply. But make no mistake, this is not public safety. This is a constitutional assault on your Second Amendment rights, your Fourth Amendment rights, and common sense.
Thanks for tuning in to leftcoastnews.net. News and information from the wacky, sometimes communist, liberal west coast of the United States. For more, visit leftcoastnews.net.
Washington lawmakers are once again targeting law-abiding gun owners with House Bill 1152, a so-called secure storage law that raises serious constitutional red flags. In this episode of Left Coast News, we break down how mandatory firearm storage requirements collide head-on with the Second Amendment, undermine self-defense in the home, and create dangerous Fourth Amendment violations by inviting government intrusion into private homes. Using Supreme Court precedent like Heller, McDonald, and Bruen, we explain why forcing firearms to be locked away at all times is not common sense, it's unconstitutional. This bill won't stop criminals, but it will punish responsible citizens and erode core civil liberties. If you care about gun rights, privacy, and constitutional limits on government power, this episode is required listening. Under HB 1152, gun owners must store weapons in a locked safe, locked container, or with a trigger lock if not being carried, even in your home. Keep guns out of plain sight in homes or vehicles. If a firearm isn't readily controlled by you, even in your own home, you must secure it. Fail, up to $1,000 civil fine. Misdemeanor, gross misdemeanor, or even felony charges if a prohibited person accesses the gun and uses it in a crime. That's right, a felony for you. Get ready, because this is where constitutional fireworks start. The federal constitutional problems with this law, the Second Amendment. Let's be clear, the Second Amendment isn't some quaint suggestion, it's a fundamental civil rights guarantee. The Supreme Court in District of Columbia versus Heller held that the Second Amendment protects an individual right to possess a firearm for self-defense in the home. That means a law that makes it impossible to use your firearm for self-defense can be unconstitutional. And here's the kicker. If you have to lock your gun up every time you're not literally touching it, including in your home, what good is it for self-defense? If a home invader breaks in and you're legally required to have a trigger lock or safe between you and your firearm, you've lost the very core right protected by the Second Amendment. Legal scholars have pointed out that requiring guns to be inaccessible when not actively controlled can, in effect, burden the right to armed self-defense. No kidding. Heller itself struck down Washington, D.C.'s trigger lock requirement when it made firearms kept in the home inoperable for self-defense. Washington's bill looks a lot like that, forcing guns into locked containers anytime they're not being carried or readily controlled. That is a constitutional red flag. There's also federal constitutional problems with the Fourth Amendment. Gun owners don't just lose Second Amendment rights, they're also on shaky ground with the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures and guards the sanctity of your home. But HB 1152 by definition invites state regulation of how you must store items inside your own home. If law enforcement can demand proof, you comply, or use violations to justify searches and seizures, that's a major intrusion into the home, traditionally the most protected space under American law. Remember, Washington's own Constitution says invasion of private affairs or home prohibited. There's no clearer invasion than politicians saying you must keep your firearm in a specific container or you're facing civil and criminal penalties in your own house. This is an abstract law. Law enforcement will inevitably use this as probable cause, non-compliant storage to justify further intrusion. It's a backdoor home inspection regime. Washington state constitutional concerns. Washington's Constitution also protects your right to bear arms, Article 1, Section 24, and your private home from invasion, Article 1, Section 7. So not only does HB 1152 threaten your federal rights, it conflicts with state constitutional guarantees as well. State courts could and arguably should hold that forcing storage mandates that cripple the practical utility of firearms in the home is a violation of those protections. HB 1152 isn't about safe storage, it's about control and compliance. Proponents claim this is common sense to prevent theft or unauthorized use, but here's the hypocrisy. Criminals do not follow secure storage laws. Criminals don't follow any of these Second Amendment laws. Theft prevention laws already exist, and even proponents admit most guns used in crimes were stolen, but that doesn't justify eroding constitutional rights. What this bill really does is burden the law-abiding, not the lawless. This comes down to the brown shirt logic of public safety. Let's call it what it is. Once you accept that government can dictate how you store a constitutionally protected object in your own home, you've handed over a toehold for future intrusions. Today gun storage, tomorrow what? Anchor it to the Fourth Amendment and the home, and this bill becomes a Trojan horse for government intrusion. If you care about your rights, your Second Amendment right to defend yourself and your Fourth Amendment right to keep the government out of your home, you cannot ignore this bill. HB 1152 is not about public safety, it's about control. So call your legislatures, show up, fight back, because if we don't defend these principles today, we won't have them tomorrow. And this bill currently has cleared both floors of the House. The minority Republicans voted against it, but of course the majority Democrats voted for it. It's now gone into the Rules 2 mode and is being reviewed to see if it's going to be held or if it's going to return to the floor for another vote. So this is the time to call your legislators and the legislators that are sponsoring this bill and let them know that you are against this, that this is unconstitutional, very unconstitutional. We have to take action. We have to stop being quiet about this stuff. We've got to make time to make phone calls or send emails at a minimum. So do what you can and reach out and contact, because this is just another erosion of our rights here in the state of Washington. Anyway, I appreciate you watching. If you liked what you saw, please like, share, and subscribe. This is Left Coast News, and we'll see you next time.